Hi, I'm Monica Bay, Editor-in-Chief of Law Technology News, and I'm here with Judge Francis. Tell us about Rule 37E.
Well, 37E is the proposed rule that deals with spoliation and sanctions, and I've taken a rather hard line in opposition to that rule, and let me tell you a little bit why. That rule would require showing of bad faith or willfulness in an instance where a court wants to impose a significant sanction for the loss or destruction of evidence. And the problem is that that puts an innocent victim in a position where it's unable to prove its case, but is also unable to get a realistic sanction if it can't prove bad faith. And that, I think, is philosophically wrong. Beyond that, there are basic problems with the draft rule. For example, it treats lawyers like criminals. It assumes that lawyers and their clients adapt their behavior not to the obligation, to the legal obligation, but to the sanction that would be visited upon them if they violate that obligation. I would much rather see the Rules Committee return its focus to defining a preservation obligation in a way that helps us to reduce overpreservation. But failing that, they've tried to deal with it from the sanctions end, which I think is a great mistake.
If you had one suggestion to litigants coming before you right now, in the light of the recent developments and proposed rules and everything else, what tip would you give litigators who are coming to your court?
I think the best tip is that they need to confront e-discovery issues early. They need to discuss them with each other, and they need to do that with a level of technical competence that I haven't yet seen.
Well, I think you have a lot of company in that wish, and a lot of our audience is watching very carefully on the upcoming rules changes. And it's a very exciting time to be doing e-discovery. And Judge Francis, I thank you so much for your time. And I'm Monica Bay. We'll see you on the next edition of Law Technology News videos.